So at this point, we are going to hear from the views from the field, from the Probation Department. The first witness is Richard Bohlken, the chair of the Commission's Probation Officers Advisory Group. He has been a member of POAG, as we call it, since 2010. Mr. Bohlken is the Assistant Deputy Chief Probation Officer in the District of New Mexico, and welcome back. And the other witness on the panel is Michael Andrews, who is the chair of the Commission's Victims Advisory Group. He's also the managing attorney for the D.C. Crime Victims Resource Center and assistant professor of the University of Maryland University College in the Public Safety Department. Welcome to both of you. Thank you.
First, I wanted to thank Judge Saris and all the commissioners for the opportunity to be here today and to comment on this proposed amendment. When POAG first learned about this proposed amendment, we reached out to representatives across the country and tried to solicit information and input from all 94 districts. And the overwhelming response that we received from across the country was positive, and this was a move in a positive direction, overwhelmingly. Over the past several years, as you all know, POAG has written and commented on several occasions about trying to come up with one crime of violence definition in the guidelines, and we feel that that's the move that this amendment makes. We'd also encourage single definitions for other terms used in multiple guidelines as helpful also. This would reduce confusion and it maintains uniformity. We like the fact that this amendment addresses the issues that have been raised with the residual clause in the Johnson case. And by eliminating the residual clause, we think that's a positive also. We received positive feedback on the enumerated offense definitions in the application notes. We believe that the contemporary generic definitions will be helpful, and the probation office, when using the categorical approach and the modified categorical approach, we already go to the model penal code and things like that. So we saw these definitions as just putting them in the application notes, and it would be useful to us. We did receive a lot of feedback that the list didn't include some offenses that many across the country would like to see, such as aggravated fleeing from law enforcement officers, shooting at or from a motor vehicle, battery on a peace officer. But we also acknowledge there'll never be a perfect list that everyone agrees upon. That's just not something that can happen. And I said during one of the breaks, I've been to many roundtable discussions on this topic, and I've been in rooms with a lot of smart people, and if there was a easy answer to all of this, the commission would have already come up with it. And so I know how complicated it is. So the list, we like the list. Maybe it could be a little better with a few additions, but we know it'll never be perfect. POAG struggled with reaching a consensus on two items within the amendment. The first was deciding between burglary of a dwelling and just burglary. We've had numerous meetings and discussions on this topic. Some like the narrowness and the similarity of the burglary of a dwelling, which is what we use now with most crime of violence definitions within the guidelines, while others like the broadness and uniformity of burglary with the approach that we take to the ACCA. So we couldn't come up with one consensus on that. Secondly, we split on the proposed changes to the requirements determining whether or not an offense was classified as a felony under state law. Many believe that the definition should remain unchanged the way it's been right now, where we look at the amount of imprisonment for the offense as whether or not it's going to be a misdemeanor or a felony under the guidelines. And this would avoid those felt would avoid unwarranted sentencing disparity amongst the different jurisdictions across the country. And then on the other hand, others believe that the proposed change requiring the offense be classified as a felony under state law would ease or simplify the application for them in a lot of cases. One of the things that we did unanimously agree on was that should the change in requirements be implemented, we like the inclusion of the phrase "at the time the defendant was initially sentenced," because across different jurisdictions, offenses change from initial sentencing to the time they complete a term of supervision. In sum, this is a good and a needed amendment. As I said before, will it fix all the issues and make it simple to apply? No, it's still going to be a complicated process determining whether predicate offenses are crimes of violence, but it's definitely a move in the right direction, so thank you.
Thank you. Mr. Andrews.
Thank you, Chairman Saris and the distinguished commission. My name is Mike Andrews, and I'm the chair of the Victims Advisory Group, and I appreciate the opportunity to come and speak with you on behalf of the crime victims community. I had an opportunity to speak to our panel as well, and we have just some recommendations for the commission to consider. First, I think the group as a whole agrees that there needs to be a simplified and standardized approach for the definition that would provide clarity and consistency. The group is also aware of the multiple different definitions of crime of violence, and they're aware of that. And I think the ultimate approach is to find some consistency where victims feel that the rules aren't changing depending on the type of crime that has been committed and which they're a victim of. The VAG supports expanding the definition of crime of violence. They propose three possibilities. One is the current element, so use, attempted use, threatened use of physical force against the person of another. Of course, they also agree that that definition of itself may not catch all the different types of crime of violence, and also agrees that a enumerated offense approach would also be consistent with some of the crimes that aren't part of that definition, such as rape, murder, terrorism, some of the things that were discussed in the previous panel. The third, which we discussed just before coming here and prior to submission of the testimony, is the other circumstances where are not caught between the definition of crime of violence or the enumerated offenses, but those will give the judge discretion to determine those relevant facts that could also consider crime of violence. Because we know that there's also situations where even the enumerated offenses don't really fall in the definition of what a traditional crime of violence would be. And this way, this would give victims a third opportunity to have the court make that determination. The one part that there was unanimous approach is if the commission is to adopt a new definition of crime of violence, is to have any type of retroactive application be perhaps taken out or not considered, for the simple fact that relitigating any new application could induce further re-victimization of victims and would cause further trauma. Two definitions that the VAG did want to comment on was the murder definition. The VAG supports the proposed definition. And the other one is the aggravated assault definition. And like my colleague here, I don't know how many different, I guess, special classifications you can come up with. The VAG would add to the list, besides the ones that I already mentioned, athletic officials, military, clergy, or public officials. These are the folks that are often the most vulnerable victims to interface with the public the most. And of course, first responders would be included.
Did you say athletic?
Athletic officials.
Those helicopter parents?
Well, one of the members of the panel indicated that there was a horrific case in Utah which a family member was a soccer referee and
Really?
was,
And then some parent hit him?
well, a player assaulted the referee. Yeah, it killed him actually.
And how frequent is that?
I probably infrequent, but they said that, you know, there's an opportunity that, you know, it's something that's not really considered. That's a kind of a rare example with the death, but they were saying about other assaults that have happened with either hockey referees, soccer referees.
Really?
And then, of course, we just saw most recently in the state of Texas where there's assault on a football referee. By two players. I don't have the statistics. It was
They
an
don't play
interesting.
football in Massachusetts.
What are you talking about? We're the home of the late game. There are others.
They just import professionals.
That's very interesting. So that was viewed as a common national problem.
Yeah, they thought that when we were going through the extensive list, and it was exhaustive, and I think you know, we were just trying to pare it down, and that was a consensus that they wanted me to bring up. Perhaps isn't on everybody's radar, but it's something to consider.
Well, thank you.
So, thank you.
Can I ask you a question, Mr. Andrews? So the last panel when we were discussing this, the issue was if we expanded our, if we went beyond the categorical approach and we did kind of take into account additional things, kind of like your number 3, relevant facts, the court could consider. There's this issue of whether it would mean bringing victims in to testify or having people come in. I don't know if you have a sense of whether or not going beyond the categorical approach, whether we, because it seems like what you're saying with retroactivity is don't do that because it'll mean that the victims have to come in, relitigate uncertainty. And I'm wondering if you have the same concerns if we were to expand and go beyond the categorical approach to include these other conduct-based things.
Yeah, thank you. Obviously, I do have that concern, but you know, with that, my clients definitely know that part of the criminal justice process is, you know, the right of testifying and the right for the accused. So, not a lot of my clients like to do that, but they know that's part of the deal. But I would probably err on, you know, to shy away from any type of relitigating those issues.
So I mean, that's the trade-off that I see, is that on the one hand you have finality, you have whatever the sentence was at the time, and there can be some closure by some victims as to the offense. And then what we're suggesting now is that closure, it's not really closure, because we'll look at it all over again. If we go beyond the categorical approach, we'll look at it all over again. So I wonder, man, maybe there's no general rule. Maybe some victims would say, well, I want to make sure that the sentence is, quote, just, is appropriate to the circumstances, and maybe some people will say, well, I have closure on this, and I have to move on with my life. Is it that there are these two sort of slightly irreconcilable views of victims, and we can't address both of them?
Yeah, no, thank you. And that's exactly right. That's always an inherent conflict that I have with my clients, especially when, you know, how much the government's asking them to participate in the criminal justice program. And, you know, for most victims, it's, you know, it's a unique situation. It's an environment. They are very, you know, it's very strange to them. And to ask them to rehash the incident that happened to them the first time, let alone, but then come back for a second or perhaps third time, is very debilitating. And that's where you see I don't want any part of this, I just want to move on. But as you indicated, yes, there's a sense of justice as well, because in the back of the victim's mind is if I don't participate, what about the next victim or the next victim that could possibly be in that situation? So, you know, I don't have an answer. I'd like to find some middle ground there where it would give a victim an opportunity or that option.
Or at least give them notice that this is what's happening, and, right.
You're exactly right, Judge, is to give them that notice of the event and then really engage them and see how much they want to participate and want to be, you know, an active victim.
Good point.
Thank you.
I had one question for you. We heard from the government that a sentence imposed requirement, which is in the immigration area, but people have been proposing in terms of limiting the predicates to the sentence imposed being at least 13 months, various proposals, would be very hard to prove. And from a probation point of view, you implemented on the immigration side. How hard is it to figure out actually what time they spent?
It's very difficult. I concur. It's still very challenging for us to obtain all the documents that we need to obtain from different jurisdictions. And if we had to come up with a definitive amount of time someone actually served, we would also have to try to get records from detention centers, prisons, different things like that. And then that brings into play sentence imposed and how much time someone actually does. Some jurisdictions give 50% off for good time. Sometimes they do 80% on violent crimes in different jurisdictions. So I think that would open it up to a lot more unwarranted disparity.
It comes up all the time in the immigration area, right? Because it's right embedded in there. So how big a deal is it in
Well, in the plus 16 and the plus
Yes.
12, it is sentence imposed, and you just have to figure out if the sentence was imposed. You don't have to figure out exactly how much time they actually did.
So it'd be, I impose 5 years in jail, and you don't have to figure out what the good time was, what the offsets were for detention centers or states. So that's why it's simple, is that you word it that way.
And the only difficulty there would be what we have right now, which is trying to track down all the necessary documents.
Well, looking at the documents, one of my great concerns is that you can't get, and maybe for good reasons, but you can't get police reports on prior incidences. It's a very uneven thing. Sometimes they're there, and I'd say most of the time they're not. Has that been a problem? Am I the only one having this problem, or is it just nationwide?
It is nationwide. Some jurisdictions are better than others. Some jurisdictions are better at record keeping than others. Across the 94 districts in the United States Probation Office, different districts some do better collateral investigations for other districts, while some maybe don't do as good of collateral investigations. So it's always an issue of tracking down the court documents and the police reports. As you know, we don't rely through the categorical approach and modified categorical approach on the police reports at all, but it is good information to have, because one of our functions is to try to give the sentencing judge all the information that we have about a predicate offense, and in a lot of cases, there are no police reports available.
Thank you. Does anyone have any other questions?
Can I just ask, has probation tried to urge Congress to do something about making it more easy for you to obtain records of conviction? So since we heard from the earlier panels and you're saying again, like, it just seems like we have this weird patchwork in the United States, and Congress should have an interest in making sure that stops and that we are able to get from every state the convictions that are the backbone of this kind of a regime. And I'm just kind of curious, has probation ever made that point, or I'm just trying to, I want to alert Congress to the fact that this seems like a real problem, like that we should be able to get these records from people, and I just wasn't sure if you knew of any effort to try to.
I don't, but that would be something worthwhile to do, because like I said, it is different across some jurisdictions. Courts charge the United States Probation Office to make copies of actual records, so it varies across the board.
Thank you.
Any other questions? I want to thank you very much for coming in.
Thank you.
Thank you.
Sharing your thoughts. We care. Probation's been always come in and terrific. That round table we had, was it last year? Everyone came in. October. That was great, and VAG, I mean, you always give us good feedback, so thank you very much.
Thank you very much.
Thank you, Aaron.